The wonder of words coming back to haunt you, and that's what's happened here. So Joe Biden, back in the 1980s, when there was discussions about changing, when you talk about court packing, you're talking about changing the number of justices on the Supreme Court. Famously, Franklin Delano Roosevelt, we're going to get into that in a moment, tried to do that. So it adds justices to the court, and you add them when, hey, things are not tipping in your favor. And right now there's a 6-3 majority, or certainly a 5-4 majority of conservative justices on the court. Doesn't mean in any particular case how it'll be decided, but there's a conservative judicial philosophy leaning into the Supreme Court. But Joe Biden has put together a presidential commission on the Supreme Court of the United States. He's done that, created that by executive order. There's a lot in there, including the number of justices, how the court works. But let me pick up on a couple of points that they raise in this executive order as to what this commission's going to be doing. And by the way, it was Joe Biden, after all, who said that the Supreme Court, that packing the court was a terrible idea, boneheaded idea, put the independence of the judiciary and specifically the Supreme Court in question for a decade. But I will tell you what it did do. When FDR did this, attempted to do it, and then pulled it back, that court, that conservative-leaning court, started approving his New Deal legislation. So it had a desired effect, whether or not it was ultimately a court packing plan that got through, which it was not. But it sent a shockwave to the court. And, Harry, you got to wonder, with John Roberts' institutional issues, would this do the same thing? Or could this do the same thing?
Well, I think it could be partially successful, and I think it would have its most profound effect on John Roberts. Joe Biden essentially has surrendered to the left's venomous and vitriolic campaign to weaken the court, to pave the way, if you will, for the left wing's agenda to be fully enforced throughout the United States. They see the Supreme Court as the chief obstacle to a progressive takeover of every single lever of power in the United States.
Which is exactly what FDR was concerned with. But, Andy, in this commission, they're going to study case selection, rules, and practices. We're going to get into that more in the next segment, but you're talking about the executive could be exercising control over case selection.
That's an alarming prospect, Jay, because that's not the business of the executive branch of government. We have 3 branches of government created by the Constitution that are separate and co-equal, and they're not to be interfered one with the other. You've got the executive branch that needs to stay in its lane, the legislative branch that needs to stay in it, and especially the independence of the judiciary. And when the executive branch of government purports to exercise examination into how the Supreme Court picks its cases and the rules that are applied by the Supreme Court in choosing the cases that it's going to hear, that's a dangerous and scary precedent because it undermines the most important thing, and that's the independence of the judiciary.
We'll get back to more of this. Packing the Supreme Court, is that the new option that the Biden administration is going to consider because they can't get their otherwise control of the judiciary? We'll take your calls on this at 1-800-684-3110, 800-684-3110. Guess what? We oppose it. Shocking development. Breaking news alert. The ACLJ opposes a court packing plan which would alter the constitutional setup of the Supreme Court of the United States. We'll talk more about that when we come back from the break. All right, so let me set the stage for you. On Friday, we got an executive order from President Biden. He issued an executive order forming what's called officially the Presidential Commission on the Supreme Court of the United States. It's got bipartisan group of experts, according to the press release. There are some conservatives on it. It clearly tilts much more to the left. A lot of former Supreme Court law clerks. In addition to legal and other scholars, the commissioners include former judges and a couple of practitioners. The interesting aspect of this, let me read you what the purpose of the commission is. And this should, any of you that are constitutionalists should be very concerned about this. I mean, really concerned about this. The commission's purpose is to provide an analysis of the principal arguments in the contemporary public debate for and against Supreme Court reform. So either for Supreme Court reform or against it. It includes an appraisal of the merits and legality of particular reform proposals, like adding justices to the court, which, by the way, does not take a constitutional amendment, just take an act of Congress, then passed by both chambers, then signed by the president. So they could do it if they wanted to. I don't know if they'd get it through the Senate, but this is what they're talking about. And then the topics it will examine include the genesis of the reform debate. In other words, why did this Supreme Court reform start? The court's role in the constitutional system. I would think that's what's specified in the United States Constitution. There doesn't need to be a lot of discussion about that. It's been settled since Marbury versus Madison in 1804. You would think that would about sum it up. Apparently not. Then it says the length of service and turnover of justices on the court. Could be a constitutional amendment to limit the service length, which turns us into a political branch, which would be a mistake. The membership and size of the court. I don't know what they mean by the membership versus the size, except FDR talked about deputy justices that would be able to vote if the other ones were over 70. And the courts, this is the thing we got to watch the most, I think, besides the numbers. The court's case selection, rules, and practices. What happens now is called the rule of four. If a case comes up to the Supreme Court, if 4 justices want to hear the case, it doesn't take a majority. If 4 justices want to hear the case, they can hear the case. But as I said in the first segment of this broadcast, FDR's court packing scheme failed in the sense that it did not allow 4 new justices to be added, but it succeeded as far as the factors that it gave to the court approving New Deal era legislation that was getting struck earlier, like 6 months earlier. And then all of a sudden there was this change. Wesley, you brought up a point about this kind of implicit intimidation factor.
Yeah, not always implicit. I mean, the left-wing Democrats, the left-wing people in the Democrat Party try not only to influence the court, such as what's going on now, but also to intimidate the court. Remember the famous speech that Chuck Schumer made on the steps of the Supreme Court, where he threatened that if they ruled a certain way, that they would reap the whirlwind and they would not know what hit them. So they're not bashful about not only trying to change the makeup or influence the court, but also intimidating the court. And it's alarming, the agenda that they not only think that America is a defective place and that our Constitution is a defective document. They think that somehow the Supreme Court of the United States, which has worked well for a long time, is also defective too.
Well, I want to first talk about the politics of this. So, Than, interestingly, they're not going. This isn't a House Senate commission. It's not a House committee or a Senate committee. This is a commission set up by the Presidential Commission.
Yeah, and Jay, the purpose of this commission, in my view, from a political perspective, is to convince all 50 members of the United States Senate, because that's the biggest hurdle they have to accomplishing this. So, Jay, I think the commission is really just aimed to try to convince those senators, Democrat senators, who are on the fence. But look, I would make this comment. You read in the description of this commission that it is bipartisan. Jay, the word bipartisan in that description is doing a whole lot of work. I went through this list of commissioners this morning, and I will tell you this. I don't think it's a stretch to say that this is a commission with a predetermined conclusion. So if this is the excuse that Senator Sinema or Senator Manchin used to support court packing, Jay, it is a very thinly veiled excuse. They need to be very careful about that.
So one of the things, we're going to get to each of the breakdowns of what they're going to look at, but Andy, the thing that just jumps out at us is the court's case selection rules and procedures. The court sets those. There's not a certiorari rule of 4 set by the Congress or by the president. But the court determines its own rules on the basis upon which it will review cases and case selection. And that line, the commission will review the court's case selection rules and practices. I think sets up has the executive really interfering with the judicial branch.
Well, that's the scary part of this, Jay. The idea that the executive branch of government, the president and the administration, is going to look into how the court picks the cases that it's going to hear absolutely ruins the balance of power established by the Constitution of the United States in the 18th century, and which we have functioned along since the founding of the Republic and the confirmation and the affirmation of the Constitution. There is no business of the executive branch of government to determine how the Supreme Court picks the cases it's going to hear. Startles me. It terrifies me. It upsets me terribly as a constitutionalist, historian, and a scholar and a practicing lawyer that the President of the United States and his administration or the executive branch of government is going to tell the Chief Justice and the Associate Justices how you're going to pick your cases, who you're going to pick, what you're not going to pick. That's none of their business, quite put simply.
Yeah, but they're trying to make it their business. I mean, Andy, you look, this is a commission that's got an agenda. I mean, they've been given an agenda here.
Oh, there's no doubt about that. The agenda is to do exactly what President Biden wants to do, and that's to grow the federal government, especially the executive branch of the federal government, at the expense of the other branches of the government. I mean, a presidential commission on the Supreme Court, that would have been unheard of under even President Kennedy. I mean, what do you mean a presidential commission on the Supreme Court? What business is it of yours to inquire into the business of the court? It is a veiled attempt to expand the power of the executive branch of government beyond the limits set by the Constitution. And it's not a very veiled attempt. As Stan said, you go through the list of these potential commissioners, and it's scary. Left-leaning academics, Harvard, Yale, Oxford, Princeton, these academics who have written on leftist subjects who've never been in a courtroom and practiced law in their life. Politicians in robes, as Senator Kennedy called them. It's a scary prospect, and one that should alarm constitutional scholars and constitutionalists, people all over the country, very much so.
Jen Psaki, the press secretary for the White House for the president, was asked about this at a press conference. Take a listen.
President Biden once said in 1983 he thought court packing was
time back machine.
Oh yeah. He said he thought that court packing was a bonehead idea when FDR tried it. So why ask a panel now to go and see if it is a good idea?
Well, first, the panel is being asked to take a number of steps, including the pros and cons on exactly that issue. But they will also be looking at the court's role in the constitutional system, the length of service and turnover of justices on the court, the membership and size of the court, and the court's case selection rules and practices. And the makeup of this commission, which was vital for the president, there are progressives on the court, there are conservatives on the court. People will present different opinions and different points of view, and then they'll have a report at the end of 180 days.
I want to repeat something she said. She doesn't deny that this is about court packing. The question was court packing. In other words, adding justices to basically get your way. And she doesn't deny that. She said the panel is being asked to do a number of things, to take a number of steps, including the pros and cons of exactly that issue. The question, Harry, of that issue was court packing, adding members to the court.
Absolutely. So this is simply a surreptitious effort to engage in what Joe Biden has labeled a boneheaded idea. That's number one. Number two, this constitutes an attempt by the executive branch to make the Supreme Court, in particular, a secondary branch. Imagine the Supreme Court creating a commission to examine executive power.
Right.
So essentially what Joe Biden is attempting to do is to dissolve the notion that there are three co-equal branches of government. Instead, he wants essentially absolute power.
I would think that John Roberts, as the Chief Justice of the United States, would take offense to this. And take offense to it because it's exactly what Professor Hutchinson just said. And that is the idea that the executive branch is going to look at how the Supreme Court decides to take cases. Forget the tenure of the justices for a moment. Forget the number of justices for a moment. But the internal working and practices of the Supreme Court of the United States, as if the executive branch, through a commission, could do this. I don't think there's a lot of these things could be done without a constitutional amendment, frankly. But the point is that they're looking. They're digging deep. Now, quickly, Than, has there been any congressional response from this yet? I mean, it just happened Friday.
Yeah, Senator Rubio and a bunch of others, Jay, tried to preempt this. They have a constitutional amendment introduced that would limit the seats to 9. So, yeah, there is action, and I think there might be some action in the states as well.
You know, you need to support the work of the ACLJ. We're bringing you this information, bringing you this analysis. You're not going to get it anyplace else this deep. This decision by this commission will affect each and every one of us. Each and every person will be impacted by this commission. Hey, welcome back. So we've got a commission now being established by the president, a commission on the Supreme Court of the United States. One of the things they're going to do is look at the historical background of other periods in the nation's history when the Supreme Court's role in nominations and advice and consent process were subject to critical assessment and prompted proposals for reform. Now, there were some in the 1850s. The biggest one, the most historically noted one, Andy, of course, is the court packing plan of FDR. But let's put that in historical context of what was going on.
What was happening, Jay, was that the president had gotten a big re-election victory in 1936, and he thought he had a mandate to rule that was sweeping and all-inclusive. And among those was these New Deal legislation that he put into effect in all the laws that he passed or through Congress passed through his efforts and his initiative. And what happened is that a conservative, largely conservative Supreme Court was ruling that those New Deal era legislation pieces were unconstitutional. And Roosevelt said, well, I can fix that. And he introduced what was called the Judicial Procedures Reform Bill of 1937, the idea of which was it gave the power to the president to appoint an additional justice to the United States Supreme Court up to a maximum of 6. That would have made 15 justices for every member of the court over the age of 70 years and 6 months, okay? The Judiciary Act of 1869, which had been in effect at the time and still is, says 1 Supreme Court Chief Justice and 8 Associate Justices. Well, what Roosevelt's plan did was cause the ire and the wrath of Democrats, his own party. John Nance Garner, the Vice President of the United States, called it an absolute outrageous attempt to pack the court. And when I think this was very interesting because I've done some little research on the subject, Henry Ashurst, who was Democratic chair of the Judiciary Committee, held up President Roosevelt's bill in the committee for 165 days, and he was a Democrat. He said, this committee is not going to be rushed into anything. No haste, no hurry, no waste, no worry. That is the motto of this committee. When the president of the majority leader of the Senate died, who was a Democrat, the bill lost its power and eventually it failed. But what it did, as you pointed out earlier, is it caused a lot of the justices to say, well, we better watch out because they're coming after us. And a lot of the New Deal legislation was passed as constitutional, that is, by the Supreme Court. But by then, the Supreme Court justices had retired, and a majority of them were appointed by Roosevelt. But the plan failed miserably, and that is a lesson of history that we have got to realize today. Keep it at 9. Justice Ginsburg said that. It has been historically the case. It is the appropriate number to keep. It has been tried and tested through time. Don't make these judges politicians.
But Harry, it did fail. I mean, Andy's right. They did not get the court packing plan through Congress, which, by the way, you didn't take a constitutional amendment to add justices to the court. It's an act of Congress, then signed by the president. But it did impact, Supreme Court historians believe, it impacted the outcome of a series of cases involving the New Deal, where the cases were going completely the other way just months before. And then when this discussion took place and became this robust discussion throughout the country, shockingly, decisions started folding in favor of President Roosevelt's New Deal.
Precisely. A number of those decisions were 5-4 decisions. And so that birthed a particular saying about the court. A vote change in time saved 9. In other words, by moving 5-4 in favor of President Roosevelt's proposals, that saved the rest of the court from being fully influenced by court packing. But it placed implicit pressure, if not explicit pressure, on the court, and the court moved left. Essentially, the court accepted the largest expansion of the executive branch in U.S. history, at least up until that time. And this is precisely the avenue, the road down which Joe Biden wants to go now.
But by the way, there's well-known Democrats, including one of our associate producers pointed out that Harry Reid, former Democratic majority leader then, said we better be very careful in saying that we need to expand the Supreme Court. quote, I think we should be very, very careful in doing so. I have no problem with the commission, but I think that the commission is going to come back and disappoint a lot of people because I think they're going to come back and say we should kind of leave it alone. I think it would be inappropriate at this time after the long history we have in this country to have term limits for judges. I think we better be very, very careful in saying that we need to expand the Supreme Court. Now, I think Harry Reid is right. I rarely say that. However, Wes has taken a good look at this commission. And this commission, if you were just taking a Democratic vote in little d Democrat, or big D Democrat, actually, Democratic process, skews in one direction. Let me put it that way.
Oh, absolutely. You know, and we all know that academia, for the most part, has moved far, far, far to the left. And looking at the makeup of this, you know, there are 8 supposed conservatives on this commission. The rest of them are liberal Democrats. But looking through the makeup of it, there's one former federal judge, Thomas Griffith. There's one executive from the NAACP, and then Michael Waldman, who is the head of the Brennan Center for Justice at New York University. Other than that, all of the other 33 members are professors. And academia is far to the left, you know, and I don't mean to disparage professors. I have some great people, but
we have one right here.
Yeah, hey, professor. But here's the deal, you know, why not put some judges and practicing attorneys on this commission? Why not put a couple of members of Congress who have served as judges in the past? But none of that is there. And without disparaging professors, you know, I would have a person who has experience arguing in front of the court ahead of someone who simply has a theory. And these 33 professors, most of them left-leaning, they have a lot of theories about the Supreme Court, not much experience.
You know, Than, to change the number of justices, people need to understand this. It does not take a constitutional amendment.
It does not take a constitutional amendment. It takes an act of Congress. And Jay, you read the quote from Harry Reid. I think he's right in large part. I do disagree with him on one very important point, though. I don't think the commission is going to advise to leave this alone. I'm with Wes. I look at the members of this, and I think they'll come back and actually advise court packing, and that will be the excuse that President Biden tries to make to push it. But, Jay, your analogy about members of Congress, exactly spot on. This would make the Supreme Court more like Congress. Do you think the American people want the Supreme Court to be more like Congress?
No.
I don't think there's a chance they do.
But they're not putting this commission in place, Harry, because nothing will happen.
Absolutely not. So essentially, this is an extension of the raucous 2018 campaign to disqualify Judge Brett Kavanaugh for the United States Supreme Court. That effort was provoked by fear that Planned Parenthood and its license to define one's own authenticity as a private project might be overturned. And then the level of hysteria has gone up ever since President Trump nominated Judge Amy Coney Barrett to the United States Supreme Court. So the left sees the United States Supreme Court as the chief obstacle to a complete takeover of every aspect of our lives, and all of the American people, all of our listeners should be engaged in opposing this particular effort.
All right, so Than, with 15 seconds, but we need to give some hope here. We're on top of this. Your team is up there, are on top of this.
Already been talking to the United States Senate in anticipation of this, Jay. More than 100,000 of our members have already signed with us. By doing that, Jay, it's going to build our voice in D.C. and make the impact even greater.
Your support of the ACLJ allows this to happen so we can stand guard and now protect the judiciary. Your support makes a big difference.
An executive order issued by President Joe Biden prompts some strong reaction tonight. Republicans are worried it's part of the Democrats' plan to reshape the Supreme Court, which currently has a conservative majority.
It was a bonehead idea. It was a terrible, terrible mistake to make.
He said he thought that court packing was a bonehead idea when FDR tried it. So why ask a panel now to go and see if it is a good idea?
Well, first, the panel is being asked to take a number of steps, including the pros and cons on exactly that issue.
Essentially, what Joe Biden is attempting to do is to dissolve the notion that there are three co-equal branches of government. Instead, he wants essentially absolute power.
The purpose of this commission, in my view, from a political perspective, is to convince all 50 members of the United States Senate, because that's the biggest hurdle they have.
What is the executive doing telling the judiciary how to run its operations?
This would make the Supreme Court more like Congress. Do you think the American people want the Supreme Court to be more like Congress?
No.
I don't think there's a chance they do.
The idea of packing the court with justices who hold your political views and who don't do what the Constitution says is what court packing means.
What I'm trying to do is to make those whose initial instincts may favor important structural change or other similar institutional changes, such as forms of court packing, think long and hard before they embody those changes in law.
This constitutes an attempt by the executive branch to make the Supreme Court, in particular, a secondary branch. Imagine the Supreme Court creating a commission to examine executive power.
Guess what? We oppose it. Shocking development. Breaking news alert.